Hi, my name is Andy Elders, and I'm a policy director at Justice Forward Virginia. I'm here to talk to you about mandatory minimums and why the General Assembly should follow through on Justice Forward's call to abolish mandatory minimum sentences in its 2021 session. So we're going to walk through a couple of questions about mandatory minimums. The first is, what is a mandatory minimum? The second is, why are they bad? The third is, how do we respond to the arguments and questions that people are going to have about mandatory minimums. And once we go through all those things, you will be ready to advocate for the abolition of mandatory minimums during lobby day. So what is a mandatory minimum sentence? To put it briefly, a mandatory minimum sentence is a sentence that the judge is not allowed to suspend down or reduce in any way, regardless of the circumstances of the case or of the personal background of the accused. That means that no matter what happened, no matter who the person in front of them is, the legislature has said, for this offense, you may not sentence below X number of years. And that is to be distinguished from a sentencing range which has a minimum or a jury minimum. Sometimes we talk about those as well, but those are all offenses where the judge is allowed to suspend down. Some of the people you're advocating in front of might confuse minimum sentences or jury minimums with mandatory minimum sentences. And it's important for you, the advocate, to understand that a mandatory minimum sentence is a sentence that the judge is not allowed to suspend below for any reason. So, what's bad about mandatory minimum sentences? Well, just on its own merit, you can just tell that telling a judge that you're not allowed to sentence below X number of years is a terrible idea. What the primary argument and the most intuitive argument is this. There are circumstances in every case. Every case is different, and judges should decide sentences based on the facts of the case. What happened? How bad was it? How did it compare to other cases? And also based on the person. Who is this person that I'm sentencing? What was their life like? Why did they commit this offense? What was happening in their head, in their mind, in their hearts at the time they committed this offense? And mandatory minimums do not allow for that level of inquiry. By their very nature, mandatory minimums do not allow for mercy for people who are deserving of it. And that's a really terrible thing for the law to do, to say that no matter what the circumstances of the case, we are going to prohibit a judge or a jury from exercising mercy. And at bottom, mandatory minimums are a prohibition on mercy. And that is, when you distill it down to its basic essence, a terrible thing for our laws to do to judges and juries. So when push comes to shove, what that means, if you're thinking about, as an advocate, telling a story, a person who was themselves the victim of, say, child sexual abuse, and then turns around as an adult and commits the same abuse, that person it wouldn't matter for the purposes of what their sentence should be, that they themselves were previously victimized. Or if that person had grown up in a home where there was physical violence, either against one of the parents or against themselves and the other children as they were growing up. And you can see the kind of impact that might have on someone. But if that person then goes on to commit a violent act, mandatory minimums don't care. Mandatory minimums also don't care, for example, if someone was intoxicated and acting very much out of their normal behavior. Mandatory minimums don't care if the person being sentenced has no prior record and has never been in trouble. And mandatory minimums don't care if the person who committed the offense was under the influences of an extreme mental illness at the time that they committed their offense. We know that in Virginia, it's very hard to assert a mental health defense, but it's very common for mental health to be a mitigating factor at a sentencing hearing. The person was bipolar. The person was in the midst of a manic episode. The person was schizophrenic and was actually psychotic at the time of the offense. Some of those would not necessarily qualify for mental health defense for not guilty by reason of insanity, but they certainly are mitigating. But mental health isn't accounted for if you have a mandatory minimum sentence. And so what that means is all of these reasons that courts can and should take into account in every other context, they're not allowed to, meaning that they're not allowed to administer justice. They're not allowed to give a reason for mercy and then give a merciful sentence. Rather, they're required by the judgment of the legislature to give the same sentence or worse in every case, no matter what the circumstances are. That's bad. That's bad policy, and it undercuts the purpose and the role of judges and juries in our system. Look, we pick judges and juries very carefully in our system, and we do that on purpose. But mandatory minimums don't allow them to exercise that discretion. The second thing that mandatory minimums fail to do is that they don't reduce crime. The idea fundamentally of mandatory minimums is that they say, look, this kind of crime is so bad that we need to instill a harsh punishment and make sure that that applies in every case, no matter what, so that people get the message and stop committing that kind of crime. But as the data has proven over the years, that doesn't work. Mandatory minimums have never been shown to reduce crime in any study that I'm aware of. When our Crime Commission studied it, they could not find any conclusive evidence that mandatory minimums deter people from crime or that they're effective in that sense. And many other states who have gotten rid of their mandatory minimums have done so without any increase in criminal activity associated with those offenses. So there's substantial evidence that mandatory minimums simply don't work. And so the idea that we would trade judicial discretion, juries' judgments, the ability to exercise mercy, that we would trade those for some substantial reduction in very dangerous crime simply doesn't work. We're paying the costs, but we're not getting the benefit of the bargain. So that's the second reason they don't work. The third reason that mandatory minimums are bad is nothing to do with sentencing itself. It has to do with the effect that having a mandatory minimum sentence has on someone who is accused of a crime but has not pled guilty and is deciding whether or not to plead guilty. Here's what it comes down to. If you're charged with a mandatory minimum offense that might require you, if convicted, to do 5 years, guaranteed, or in some cases, a mandatory life sentence, that creates extraordinary leverage for a prosecutor who wants to avoid having a trial and wants to secure a guilty plea. That prosecutor might be thinking to themselves, I don't need this guy to do life, but if I can convict him and I can offer him 15 or 20 years and he has to agree to that sentence to avoid facing a mandatory life sentence, that can be a very powerful tool in coercing a guilty plea out of someone who might not want to plead guilty. The fundamental purpose of our criminal justice system is to have trials that determine whether or not the person accused is guilty. But those trials don't happen when there's mandatory minimum sentences on the board because of the incredible leverage that it gives. And as a result, we've seen that courts have seen a substantial decline in jury trials. And in 2019, only 1.3% of jury trials of criminal cases ended with a jury trial. That's too low. That's too many people who are giving up their right to a trial, too many people who are giving up their right to say, I didn't do this, and instead being forced to accept a plea that they otherwise would not. Mandatory minimums play a big role in that, and getting rid of mandatory minimums is yet another way to get rid of the trial penalty and give people back their right to say, I didn't do this, I want my day in court. The fourth reason that mandatory minimums are bad relates to the way they're applied. The Crime Commission found, when it studied this issue and reported back just this week, that mandatory minimums are not applied in a way that is racially equal or racially proportionate. That instead, the number of people choosing and the number of people serving mandatory minimum sentences in Virginia DOC facilities and Virginia prisons is disproportionately black and is disproportionately male. And that's just the people who were sentenced to mandatory minimum offenses, as opposed to people who are charged with mandatory minimum offenses, who as a result gave up their right to have a trial and then pled to non-mandatory minimum offenses. So what we're seeing across the board is that prosecutors are more likely to charge mandatory minimum offenses against black people, and that they're more likely to make plea offers when they have that leverage that disadvantage black people. And that's not about prosecutors being racists. It's about prosecutors looking at the people that they're making plea offers to and being subject to the same structural and the same systemic racism that everyone is subject to. if you look at someone's prior criminal record, black people are more likely to be over-policed, less likely to get dismissals, and so they're more likely to have a criminal record. If you look at the kinds of offenses that are charged or the kinds of offenses that are seen by the police, when you live in a population that's over-policed, you're more likely to have an arrest record. You're more likely to have spent time in jail or prison. And those kinds of determinations are how prosecutors decide who to charge with mandatory minimum offenses, who to let off the hook for mandatory minimum offenses, and give non-mandatory sentence options for plea agreements. And they're also the type of situations where a prosecutor looks and says, okay, this person, I'm going to drop their charges as opposed to going forward. And study after study shows that those kinds of decisions routinely are made against black people in our system. And Virginia's current prison population shows the effects of that, which is that 20% of Virginians are black, but over 50% of our prison population is black. In the end, every punitive measure that you put into our criminal justice system ends up being used against black people. And so when we talk about whether or not we should have mandatory minimum sentences, that is at its core a racial justice question. So I want to end with a couple things that you can say in response if you get asked questions about mandatory minimums. The first is, well, does that mean we're just going to let these people go? And the answer is absolutely not. If you get rid of mandatory minimums, you allow judges and juries to fashion what they think are fair sentences. Some people are still going to get life sentences. Some people are still going to get 30 and 40-year sentences from juries. But the juries won't be forced to do that against their will. The judges won't be forced to do that against their will. Fundamentally, what a mandatory minimum sentence means is we, the legislature, think that some jurors or some judges aren't going to give enough time, and we want to force them to give more. And the law should not do that. Another thing you're going to hear is, well, what about these horrible offenses like child rape or subsequent distribution of drugs? Why shouldn't those people get lengthy mandatory sentences? And the answer is this. You can't approach sentencing policy from an assumption that everyone in the system is guilty. Those sentences have an effect on people who are accused of terrible crimes, some of whom are not guilty. That sentencing process has to come at the end, but that fact that it comes at the end doesn't mean that it doesn't affect what happens at the beginning. And if you're charged with a mandatory life offense and you're not guilty, you're going to think twice about pursuing your trial rights if there's a mandatory life sentence at the end. So we can't just assume that people are guilty and work backwards and say, okay, well, it's okay to sentence them harshly, because it's not just about sentencing. It's also about making sure that they have trial rights. But also, the people who commit the most serious crimes are often the people with the most mitigation, who have been through the most terrible things in their lives. And to do justice, courts and juries should be able to consider those stories in full and then fashion what they think are fair punishments. So that's mandatory minimums. It's a complex issue, but we're excited about attacking it, about abolishing mandatory minimum sentences and allowing for fair trials and fair sentences in Virginia going forward. Thank you, and I hope everybody has a great lobby day in 2021.